Welcome. My name is Tamara Lawson, and I'm the Dean of the University of Washington School of Law, and also standing in for our colleague, the president of AALS, and on her behalf, in her stead, I welcome you all to the AALS Teach-In webinar series on professional independence and the legal profession. This is a six-part series developed by our immediate past president of the AALS, Dean Austin Parrish, and it focuses on issues related to professional independence in our legal profession. It features leading lawyers, academics, and distinguished speakers from across the country. These sessions are open to students, staff, and faculty at law schools nationwide, and lawyers and law firms, and others in the legal community. And for students joining us, a special welcome to you. And please check the web page where there's additional details about a writing competition associated with this series and a digital certificate for attending at least 5 out of 6 sessions. And to my colleagues in the Academy that are joining us today, please share the information about this series widely with your professional networks. The topics today include defending America's independent judiciary and the rule of law. However, we also have 3 more weeks of these webinar sessions, and in the next week's sessions, we will have topics on separation of powers and constraints on the executive, another session on the U.S. anti-corruption policy and changing landscapes of international enforcement, and a separate one on the profession, the market, and the state, reimagining professional independence for a VUCA world. And the 2 first sessions of this webinar teach-in series are available as a recorded link on our website, on the AALS website. And those sessions are on executive powers and the federal investigation involving law firms and principles for professional independence. So please use those references if you missed those sessions. So I thank you again for joining us today. We have our distinguished colleagues here from the University of Washington. We have Judge Robert Henry, who is our inaugural jurist in residence for the rule of law here at the University of Washington. And we have Hugh Spitzer, our professor and associate dean emeritus at the University of Washington. And I'm so fortunate to have them as my colleagues. And I want to take a brief point of privilege to just share the engaged work that the University of Washington, as well as the law school itself, has been engaged in around the rule of law. We've been working on rule of law issues in the classroom, across the campus, in media commentary, and we started a rule of law fellows program for our students. And we are very proud to share and announce that next week we will be having an engaged 2-day symposium on the rule of law. And I'm sure you'll hear more about that during the presentations. We also participated across the university in the Provost series about the power of the presidency. We have engaged and are a full member of the Global Rule of Law Academic Partnership, which had its first conference in Toronto last year, in which we were a co-sponsor and participated in the plenary sessions and presentations. And we have held separate sessions here at our law school, Gates Hall, on the state courts, including our Chief Justice from the Washington Supreme Court, engaging with our students, faculty, and larger alumni community on these important issues of the independence of the judiciary. And lastly, as I mentioned, we started a Rule of Law Fellows initiative for our students, and they have been researching the issues of the rule of law for the last 1.5 years. Their research is available on our website and cataloged by our law librarians so that their research can truly serve the public good and be used by many others working on these issues. It's really without further ado that I pass the mic to my colleagues, where they're going to share with you detailed information as it relates to our most important work at the moment, dealing with our symposium, dealing with the independence of our judiciary, and our upcoming symposium is entitled Neither Sword Nor Purse. And you know where that comes from. But without further ado, I pass it to our experts.
Thank you, Dean Lawson. As she mentioned, we are going to have a symposium, a national symposium here in Seattle next week, where we have retired judges, scholars, journalists coming to talk on panels and about what to do about the current threat to our independent judiciary. And that is simply what the topic is for today's discussion. We're going to unpack the concept of an independent judiciary, a concept that most people subscribe to in the United States, but don't necessarily think through very much. We're going to review why judicial independence is a real concern in America today, and then focus on what we mean by judicial independence. And we're going to see that there are several kinds of judicial independence and different things that we need to do to protect each kind. Judicial independence is, in fact, under attack these days. We have senators, members of the House, state legislators threatening impeachment proceedings against federal judges whose rulings they disapprove of. And President Trump, former AG Pam Bondi, and even some US attorneys are publicly attacking what they call rogue activist judges. And we're seeing personal threats to individual judges. For example, my colleague here today, Judge Henry, who served as the chief judge in the 10th Circuit, once upon a time received an envelope with some white powder in it. You might elaborate a little bit about what was that like? What did you do?
Well, unfortunately, threats to judges have been around for a long time. They have, in fact, markedly increased, and the rate of threats has gone up now. But my secretary called out to me one day and said, "Judge, could you come in here?" And I walked into her desk, and it was covered with this white powder. And she said, "I opened this envelope, and this white powder came out, and here there's a note here that says, 'You've now been exposed to anthrax, and you're going to die a miserable death,'" which I was not particularly interested in doing that day. And so, fortunately, one of my judicial colleagues had posted an email telling about he is a member of the LDS Church, and there was an attack on the church in Salt Lake City with this so-called anthrax. Most of these attacks, it turns out, were talcum powder, and they were completely fake. But you don't know that at the start, and it is kind of a terrible way to go, anthrax. So I called the FBI, and they said, "Oh, well, that's sad that you get those letters like that, and we'll come by in a couple of days and check it out." And I said, "No, we won't. We appellate judges don't usually act by ourselves. We need a panel of three to do anything. But I'm going to see what I can do by myself if you don't get someone over here immediately. I don't know whether this is the real thing or not. But if it is the real thing, everybody in this office has been exposed, and it's very, very dangerous." So finally, I got the FBI convinced to check with the state immunologist and so forth, and they finally sent an expert, and we determined from the outset that it was unlikely that it was real, and it wasn't in fact real. However, a few weeks later, people died in the House of Representatives post office because, in fact, one of those envelopes with the white powder they had someone had determined a highly contagious anthrax bacillus that could go in an envelope and indeed was so fine that it could work its way out of the envelope. So that I don't think there were many judges, and for the life of me, I don't know why they picked me, um, but it does not make your day
Right.
when that happens.
And here in Seattle, U.S. District Court Judge Robert Lasnik received an anonymously ordered pizza, as did his son. And those pizza deliveries have an implicit threat. We know where you live and you are in danger.
Yeah, we know where your
And-
son lives.
And we know where your son lives. And the son of New Jersey Federal District Court Judge Esther Salas was shot and killed at their home by a disgruntled anti-feminist lawyer posing as a FedEx driver. And her husband was critically wounded. Now, Chief John Roberts has responded to all of this in several public statements. He's labeled our independent judiciary as the crown jewel of our system of government. And he's repeatedly said there are no Obama judges or Biden judges or Trump judges, and that federal judges are just that, individual jurists. He has strongly pointed out that impeachment is not an appropriate response. Sorry, we have a little double stuff here.
Yeah.
Impeachment's not an appropriate response if you don't like a judge's ruling. The right response is to appeal, and he has stated that threatening statements about judges by politicians are dangerous because they actually encourage physical attacks. Last month at Rice University, Chief Justice Roberts said that while legal opinions are always subject to scrutiny, personally directed hostility is dangerous and that it's gone too far. So this suggests that America is facing a real threat to judicial independence. But let's dig down a little more into what judicial independence and judicial impartiality really mean, what they're fundamentally about, and then what other issues this raise. David Levy, a former federal district court judge in California and then dean at Duke Law School, suggests that you can unpack the concept of judicial independence from a couple of different angles. First, there's decisional independence of the individual judge from outside pressures or inducements when deciding a case, versus independence of the entire judicial branch as a whole. And then another angle is the reality of fair, impartial courts versus the appearance to the public of fair, impartial courts. So we're going to drill down on both these frameworks or angles in a little more detail. Now, decisional independence, this is a very old concept. The ancient Romans were committed to an ethic of independent jurists on point of law, even though in the Republic, in large criminal cases, they used to bring the entire body of the citizenry to vote on whether people were guilty or not. And that was pretty prone to overheated rhetoric and bribery. So in the empire, they gradually shifted to using professional state-appointed judges. But on points of law, legal commentators and advisors insisted on independence on legal questions. And this got the famous jurist Papinian into big trouble when he declined to issue an opinion justifying the Emperor Caracalla's murder of his own brother. Caracalla didn't like this, and he had Papinian assassinated. That's a picture there from the Renaissance, 1,000 years later, of Caracalla's goons killing the jurist Papinian. So the idea of individual decisional independence was later actually embedded in Justinian's code, which made it a crime for a judge to take any external factors into account, like personal interests or bribes. Now let's fast forward to the 17th century. King James I tried to pressure his judges, including Lord Edward Coke, pictured here, to issue rulings that the king liked. The king even kicked Coke upstairs from the Court of Common Pleas, where he was the Chief Justice, to the King's Bench because he didn't like Coke's decisions. But Coke persisted, emphasizing that the king himself was subject to the common law. And Coke wrote that he visited the king in 1610 and told him in person, you can see the quote on the screen, that God has endowed his majesty with excellent science, meaning knowledge, and great endowments of nature. But his majesty was not learned in the laws of England. Coke added in his tale about this visit that the king was greatly offended. But Coke persisted. And then in the following century, in our Declaration of Independence, one of the prominent grievances against King George III was that he has made judges dependent on his will alone for the tenure of their offices and for the amount and the payment of their salaries. So let's talk a bit more about modern threats to decisional independence, which is manifested in a number of ways. Obviously, physical threats, personal threats to judges might make a few judges think twice about how they rule, but not many. Our judges are pretty resilient. But these threats can get to some real extremes. In 1989, the entire judiciary in Colombia had to go on strike to demand enhanced personal security because so many judges had been murdered by cartel hitmen. They got the increased security. And there are other kinds of threats to decisional independence, the decisions that individual judges make in cases. We don't see outright bribes in the United States much, but there are direct or implicit promises of higher judicial appointments that could affect how a very few federal judges approach some politically sensitive decisions. I can think of just maybe two Trump appointees who might conceivably try to keep him happy on certain rulings in hopes of higher appointments, but this is pretty rare. I do have some concerns about President Trump's decision to completely ignore ABA ratings in making judicial appointments, and also his more recent decision to ignore Federalist Society recommendations, because he soured on the Federalists when a number of the judges they recommended in his first term, once confirmed, began to call individual cases the way they saw them. And this meant that on occasion, the Trump administration lost. President Trump does not respect the decisional independence of individual judges in their rulings. And I'm concerned that he will do some things that modern presidents have avoided, such as asking judicial candidates to explicitly commit to specific positions on issues as a prerequisite to appointment. Now, of course, once confirmed by the Senate, the president can't hold them to those commitments, but it is a concern. Obviously, presidents can and do make federal appointments based on the background, attitudes, and judicial philosophy of prospective judges. In the last hours of his Federalist administration in 1800, President Adams appointed John Marshall, a committed Federalist, as Chief Justice. That appointment made a huge difference in the court's philosophy for the next third of a century. Yet just because Marshall was a Federalist and a nationalist in outlook, he and his colleagues were able to maintain decisional independence in individual cases. Now, obviously, he had to engage in some fancy footwork in Marbury versus Madison because of the threat of Jefferson ignoring a Supreme Court decision. But Marshall got the last word in Marbury because it established the broader institutional independence, the supremacy of the Supreme Court in constitutional questions. And, but still there are political and academic arguments out there to the effect that decisional independence isn't all that it's cracked up to be. One is that individual judges can't be thought of as independent if they were appointed in significant part because of their background philosophies. In my view, though, this misses the point. Marshall, Story, Toni, Holmes, Hughes, Warren, Rehnquist, and virtually all the others were appointed because they had background attitudes that were compatible with the views of their appointing presidents. But once on the bench, our nation's ethic of judicial independence gave them the strength to call cases the way they saw them. Now, Chief Justice Roberts has a formalist philosophy. He's something of an originalist, and he has a constrained view of the role of the courts. That shows in his decisions, many of which I don't agree with. But as far as decisional independence is concerned, I'm convinced that he consciously rejects political pressure in specific cases. History is replete with justices and judges who turned out differently than their appointers expected. Warren, Rehnquist, O'Connor, Souter, and Amy Coney Barrett, to name a few. But this is exactly why the founders insisted on protecting federal judges from pressure by giving them lifetime appointments and protecting their compensation. Sometimes members of the general public have trouble understanding why judges don't decide the way a majority of the voters would like. But the Constitution has built-in protections against majoritarianism, and it's meant to protect individual liberties from majority attack. And those protections are enhanced by the decisional independence of judges. Another critique of decisional independence comes out of the legal realist movement of the 1920s and 30s. The realists asserted that when you look at things empirically, judicial decisions are sometimes based on what side of the bed the judge got up on, what the judge ate for breakfast, or whether the judge is in a bad mood because of a family squabble. But that also misses the point. Surprise, judges are human beings. Their rulings are influenced by their personal experiences in their own lives, but across the board, these kinds of factors don't significantly affect their decisional independence, particularly at the appellate level. Judge Henry, I hope you didn't make too many decisions based on which side of the bed you got up on.
Occasionally, if breakfast was really bad.
Oh, if breakfast was bad. Oh, boy. Another concern raised by academics and some empirical research is that elected state judges in almost half the states, they're elected or they have to stand for periodic retention votes. Are these judges more cautious in election years, especially in light of the amount of money being poured into some state Supreme Court races? Personally, I think it's enough to switch to merit systems for judicial appointments, but big picture, the vast majority of state judges are so personally committed to decisional independence that in the vast majority of instances, they just continue to decide cases the way they see them. It's ironic, though, that in Midwestern and Western states, which tend to elect their judges, the reason those states' constitutional drafters built in judicial elections in the 1800s was that they thought it would make the judges more independent because they wouldn't be beholden to individual governors, senators, or special interest groups. And I know several elected state Supreme Court judges who say they actually feel more independent because they're responsible solely to the voters. Also, many, perhaps most elected judges follow the traditional ethics rule and avoid learning who is contributing to their campaigns. Now, let's shift to institutional independence. This involves the ability of the judiciary as a whole to govern itself as well as governing the bar and to function as a truly independent branch. In Federalist number 78, Alexander Hamilton, which, by the way, Judge Henry's become something of an expert in, Hamilton wrote, "There is nothing to fear from the judiciary alone, but everything to fear from its union with either of the other departments. And he also said, as you see on the screen, the complete independence of the courts of justice is peculiarly essential in a limited constitution. A limited constitution meant a constitution where the individual branches of government are limited in their powers. Now, remember, Hamilton and his compatriots were steeped in Montesquieu and Montesquieu's ideas about separation of executive, legislative, and judicial power. But Hamilton expanded the independence and role of the judiciary way beyond what Montesquieu had ever contemplated. After all, remember, the Americans were just coming off a successful revolution, where, as I mentioned earlier, one of their principal grievances against George III and his governments was that they messed with colonial court systems and tried to control the tenure and compensation of the judges in order to direct the outcome of cases. So this is precisely why the Constitution devotes an entire article, Article 3, to the judicial branch and provides for life terms for judges and protected compensation. Thanks to the Constitution and to John Marshall, there's now widespread acceptance that, number one, the Constitution is positive law. Two, the judiciary interprets that law. And three, the Supreme Court has the last word. Now, obviously, Congress has a huge amount of control over the existence of federal courts subordinate to the Supreme Court and the jurisdiction and range of cases for those courts. But by and large, presidents and Congress have recognized that the country needs federal courts, particularly given the need for courts with diversity jurisdiction under Article 3, Section 2. So Congress could pressure the judicial branch somewhat through the budget process, but we don't see massive use of that. We see a little more of it in the states when legislatures get grumpy with their own Supreme Courts, telling the legislators they have to spend money on things like schools. Presidents can complain, and they do, about courts and judges. Think about Franklin Roosevelt, who asked Congress rhetorically, "Is there anything that this court will approve?" That was after the court struck down several of his economic programs. But he didn't use language like rogue or corrupt judges. And when Roosevelt tried to tinker with the Supreme Court's composition through his court packing plan, he spectacularly failed because the public, including a lot of New Deal Democrats, rejected the idea of the president and Congress messing with the independent judiciary. President Trump has tried to challenge independent judiciaries in a few ways, including his recent proposal asserting that state courts should not be allowed to control ethics proceedings against Justice Department lawyers without Justice Department approval. That idea is going nowhere. It has received huge pushback from state Supreme Courts, including very conservative courts that are just as protective of their turf as anyone else. Trump has also tried a gimmick of turning up at the birthright citizenship oral argument in person, hoping that his presence would somehow sway the justices and assure a favorable outcome. That seems to have been something of a flop. In some other countries, we've seen coordinated attacks on the independence of the judiciary. Of course, there's no such thing in Russia. And in Poland and Hungary, and even Mexico and Bolivia, we've seen the other branches, especially the executive, trying to reshape the judiciary by removing judges or making them subject to popular election. Things in Poland are looking much better nowadays. And another hopeful sign is the example of Pakistan, where their president's attempts to suppress the Supreme Court on several occasions in 2005, between 2007 and 9, and then again in 2015, each time was met with massive and successful demonstrations by lawyers in all major cities, demonstrations in which the attorneys all dressed up in their suits, ties, and sometimes their robes. So lawyers have a special role in acting to protect our judiciaries as independent institutions. Thankfully, the ABA, the Federalist Society, the American Constitution Society, and other legal groups from left to right are speaking out in defense of our courts. Now, finally, let's shift over to the other prism through which we can analyze judicial independence, actual independence, and the appearance of independence. As I've argued today, most individual judges, regardless of their background philosophies, remain committed to decisional independence, that is, impartially deciding each case on its own factual and legal merits. But do judges and the judiciary appear impartial and independent? One guarantee of this are codes of judicial conduct that bar self-interested rulings, require judges to keep a distance from politics, and require them to treat all parties with respect and so forth. Some judges and academics have argued that while judges can speak publicly about an independent judiciary as a concept, they ought to refrain from getting too vociferous because judges who respond too strongly to rhetorical attacks will appear to be engaging in politics. Another argument is that judges aren't technically sophisticated enough to engage in kind in fighting social media attacks. And this is why some judges, like U.S. District Court Mark Wolf of Massachusetts, recently quit his court so he could feel that he could freely criticize the current administration. Judge Henry, I mean, what are your thoughts about how strongly should sitting federal judges and other judges be able to sort of defend themselves and their branch against attack?
Well, I think judges feel uncomfortable defending themselves because there's been a culture of waiting for other people to defend them, and it's one has to be judicious. I remember when I was a baby judge a long time ago, I wrote a decision for a panel that involved a prison transsexual who wanted some medical care, and the government filed a response to his petition and added some material to that, and the judge ruled without giving the prisoner the chance to respond to the new material. The judge just got in a hurry and he just forgot it. So I wrote an opinion overruling the judge, and I wrote it as a non-published opinion. And my chief judge, Judge Stephanie Seymour, said, we're having a lot of problems with this. So I think you need to publish this decision. And the judge was a very celebrated judge, Judge Mage, who later tried the Oklahoma City bombing case. An excellent judge, wonderful judge. Just he forgot to dot one I or cross a T. And so I simply took the opinion back, polished it up a little bit, tried to make it sound a little more erudite, and then we published it. Shortly afterwards, Orrin Hatch, the chairman of the Senate Judiciary Committee, wrote an op-ed piece in the Wall Street Journal saying that I had found a constitutional right for estrogen in prison transsexuals. The 10th Circuit's that kind of place, really left-wing crazy. Well, of course we didn't find that. And I could not speak out. And then somebody else wrote something. I think it was National Review and it was so frustrating. So I researched the ethics, and I found that after the case was all over, that a judge could speak to a legal group and sort of explain the reasoning of the case and so forth. But you had to wait until the case was all over. And fortunately for me, two members of the local Federalist Society wrote letters defending me and pointing out that, in fact, that the case was completely misconstrued. I did what a lot of judges do in that situation. I wrote a letter to Senator Hatch, and I pointed out in the letter to Senator Hatch that I knew that he didn't have time to read the opinion that he decided to comment on in the Wall Street Journal. And I suspected that maybe his staff didn't have time to read the opinion that they helped him comment on.
And this was a private letter to.
Well, I'm getting there.
Uh-huh.
And so then I went on to tell him that, but there's a great thing, Senator Hatch. You don't really have to read the opinion because West has come up with these keynotes. You don't have to read the whole thing. You can just look at these keynotes. And if you look at keynote number 6, it says, while there is no constitutional right to estrogen, there is a right to be heard about the quality of medical treatment. So I read that letter again 2 or 3 times, ran it by my clerks, and then put it in my desk drawer and never sent it. He was chairman of the Judiciary Committee, and he obviously had not read the case. What he did, I think, was unethical. But later, I met with the American College of Trial Lawyers after the case was all over and explained what happened, and that is permissible. So it's really kind of up to the bar to defend judges, but I've noticed recently, both in Canada and in the United States, the Code of Conduct Committee has revised. There was once an absolute bar. You just almost never spoke out about anything. But because it's getting bad enough, I think that the ethics rules are relaxing and letting judges speak a little bit, but it's still it's difficult, and it really is better if the bar and the academy will defend the judge.
Right. I mean, it's very tricky because obviously judges need to remain judicial in character. And one thought I had when you said that you put that letter in the desk drawer is that you were defending the independent judiciary as a whole, since Senator Hatch was in charge of the entire Judiciary Committee at that point, and he could do some mean things, I guess, to the whole branch. Another thing in dealing with the appearance of impartiality, I always find it troublesome that the media constantly identifies federal judges in terms of who appointed them. Unfortunately, there's nothing we can or should do to keep the journalists from reporting facts. They're doing their job. But what we can do, as Chief Justice Roberts did, is to reiterate that we don't have Obama judges, Biden judges, Trump judges. After all, Trump has learned to his dismay that there actually are not very many completely reliable Trump judges. To my mind, one problem with the appearance of impartiality is in the 8 states where judges run for elections on partisan tickets for Supreme Court. And no matter how committed individual justices might be to impartiality and decisional independence, partisan judicial elections just look like hell. And in my view, those states should just stop doing that. But anyway, to sum up, and I'm echoing Judge and Dean David Levy again. Number one, fair and impartial courts are essential to a successful democracy. 2, judicial independence isn't for the benefit of the individual judge, but so that the judiciary as a whole can be fair and impartial. And then we've got this difference between decisional independence of the individual judge versus institutional independence of the entire branch. And it's important to keep that in mind. Then the selection and compensation and tenure is important to securing judicial independence. And an independent judicial culture needs to be observed and preserved. Judges need to avoid policy making that's within the legislature's or the executive's purview. This can be tricky given our tradition of common law courts in developing the law in the context of individual cases. And the courts have the last word in interpreting and applying constitutions, but judges need and courts need to be careful and mindful and respectful of the other branches' roles. And finally, the appearance of fairness and impartiality is almost as important as the reality. Thank you for your attention today, and we would be very pleased to field questions that you might have. I think that the folks at the AALS,
Chat.
oh yeah, let's hop up to the chat here. Oh yeah, we do. We have 7 questions.
Well, I think only maybe one. If you
Let's
scroll down.
scroll down. Let's see. If you've got questions, please put them in the chat.
I guess.
Let's see. Going once. We'll give you a few more minutes to.
If we don't have a question, maybe I can fill the void at the moment and ask both of our experts. What do you think the highlight, people might want to log in. We have hybrid opportunity to log into our symposium. What would be, the reason or the highlight that they need to catch from our symposium? Because this is a teaser. You've really whet the appetite, Professor, around all the deep issues, and Judge, the realities of what you faced on the bench. What additional is the symposium going to highlight?
We actually do have a couple of questions, but let's just say it's a little bit about the symposium. Next week, it's going to be on Friday all day and Saturday morning. And then it's Pacific time. It starts bright and early in the morning on Friday. But one of the highlights would be to listen to retired Judge Michael Ludig give a keynote address. I don't have my calendar with me on that, but it's probably or roughly around 9 or 9:30 in the morning. And you can get the agenda at the University of Washington Law School's website. Ludig would be wonderful to listen to. And then we'll have a panel immediately followed that's chaired by former Attorney General and former Governor Chris Gregoire from Washington State, with a number of judges who will be discussing Judge Ludig's address.
Let me just say one thing about Judge Ludig. There's been some confusion, unfortunately, about whether this issue is partisan or not, because of the Trump administration has really taken such egregious behavior. Mike Ludig is a card-carrying Burkean Republican. He sent a number of his clerks went to work for Justice Scalia. His conservative bona fides are without question. When he was not appointed to the Supreme Court, he was, I think, narrowly overlooked. He left the bench and went to work for Boeing, which is not, a radical rogue Marxist communist sort of place, and is just a very stable stalwart on the board of the National Constitution Center. Just a remarkable fellow, but he's very concerned. He's very concerned about what is happening. And when the dean and I discussed this symposium at the outset, I said, he's the one I want us to get because he's making the case better than anyone else. We're very, very fortunate to have him. We have some other great speakers too. So this is not a partisan issue. Indeed, the Society for the Rule of Law, one of our other sponsors, is a very conservative Republican Federalist Society oriented institution, but they're deeply concerned about the independence of the judiciary.
Let's see. One question is, we always say that there are no, it's a name judges. My question is whether the academy or the practicing bar actually believes that. I see that there aren't Obama judges, Trump judges. Do lawyers and do academics really believe that? To be sure, judges sometimes disappoint the president who appointed them, but that's not inconsistent with the same judges who are following the appointers' preferences for assumed preferences. Yeah, I'll tell you what my thinking is on this, and this is why I tried to bring up John Marshall. I mean, when Adams appointed Marshall, he wanted a federalist. He wanted a nationalist. And Adams had just been beaten in an election by Jefferson, who was not a nationalist. He was very oriented toward the states. And indeed, Marshall was a federalist for the rest of his life, serving as the Chief Justice. But that is background philosophy, and it will drive results, and it may make presidents happy that they appointed that person. But when you get to the individual cases, whether it's like a tariff case or a birthright citizenship case, each of the judges on our Supreme Court, no matter who appointed them, is going to look from his and her perspective. They're going to look at the case individually and try to do the best that they can. So anyway, that's my thought on that one.
I do think, I mean, one thing jumps immediately to my mind. The cases that are controversial are very few. The great majority of cases that the Supreme Court of the United States decides are not 5-4 decisions, and they're not particularly controversial. But it is important to have good judges who are not Obama judges or Biden judges or Trump judges. And so we do in these controversial cases, what would you think? 5%, 10% of the cases?
The most.
You know, they appear on areas where the Constitution is amorphous, and there are some differences of opinion. But judges take an oath to follow the law, and I think most of them do and try very hard. I'll give a personal example. I was the Attorney General of the state of Oklahoma. I carried out the first death penalty in the state in a number of years because there had been a Supreme Court ruling in Furman versus Georgia that paused the death penalty. It was ruled unconstitutional as it was carried out. And I went on the court, the 10th Circuit. I was appointed by President Clinton. Incidentally, there were no litmus tests. I was not asked, how will you vote on this, or what's your feeling about abortion, or this or that. As the more I got to working with death penalties, I'm now completely opposed to the death penalty. I think it's wrong in just about every possible way. And I voted to affirm it many times because it was the law. And I have a friend who wrote a book, and a chapter was entitled Things I Could Go to Hell For. Well, that may be one of the things I can go to hell for, is following the law. But that is the oath I took, and I think judges really try hard to do that. And that's why, bringing up your other point, that's why it's so bad that attorneys no longer have any input into the appointment process of the judge, because only attorneys know about judicial temperament. They asked Felix Frankfurter if giving a person a black robe, that is, giving them life tenure, made them a better person. And they said, if they're a good person to start with, if they're a good person to start with, making them putting a black robe on them will make them a better person. If they're a schmuck and a jerk, a black robe is not going to help them. And so it's pretty important to have this input, and that it's so tragic that this administration won't even seek the opinion. And I think if I were the ABA, I'd do it anyway.
Yeah.
I,
Well, here's one of the questions in the chat.
I got it.
What do you think is the best way to push back on the president's attacks on the judiciary? And well, speaking out. This is where lawyers, law students, and everybody who cares about this, people need to speak out. People need to get together, like we're doing with our symposium next week, and then the other thing is really to push push members of Congress and senators to themselves speak out on the need to protect the judiciary, because as we've discussed, the ability of judges to fight back is limited by the need for them to be cautious in certain kinds of ways and to be judicial in character. So what are the other?
There's a couple other questions that have come in related. Is there any way to enforce judicial independence? As the audience is thinking, it seems like it's relying on good behavior, almost like, you know, Judge Henry's stories and his personal character. But is there other ways to enforce judicial
Well,
independence?
yeah, we probably both have opinions on this one. At the federal level, for every court except the Supreme Court, there's a code of judicial conduct that is enforceable. And Judge Henry, you may have been on some of the committees
I was on that.
that manage that. Unfortunately, the Supreme Court has not seen fit to make itself subject to binding ethics rules and to the same enforcement process. And they should make themselves subject, even though it means that they would be subject to critique from their colleagues on lower courts. I don't know, Judge Henry.
I completely agree with you. I mean, taking an expensive trip where you fly a jet to a yacht and then taking the yacht and doing that and then going to a really fancy hotel and spending some time there and maybe doing a little fly fishing while that's not difficult. That's not a close case. You can't do that. It can't be done. Judges, as Judge Ludig says, it is a bit of a monastic life, and if you can't handle that, you shouldn't be in it.
Right. At the state court level, many, perhaps most state constitutions have systems set up for the enforcement of violations of the ethics rules. For example, here in Washington State, we have an independent judicial conduct commission which investigates and then makes recommendations to the Supreme Court. And I can recall one member of the Supreme Court who wound up in front of the Commission on Judicial Conduct twice. Once for speaking out at a rally, they're speaking out on a political topic. And interestingly, in that one, the commission recommended that he be disciplined, but a Supreme Court comprised completely of appellate judges, because you couldn't have his own colleagues sitting on the case. They ruled that he had a First Amendment right to speak out. On the other hand, a second time around, he visited a prison when there was a case involving the conditions at that prison, and went investigating facts himself that were not in the record, and he did get dinged on that one. And it is important to have those systems going for enforcing violations by sitting judges.
So as you know, lawyers have the ability to ask these ethical questions and, some kind of safety ombudsman or the state bar has a, hotline of some kind. What about judges who find themselves in a dilemma? Are they able to ask questions about ethics or judicial
The
independence?
Code of Conduct Committee of the Judicial Conference of the United States, on which I served for a while, a judge may submit a letter to them detailing a fact pattern and saying, can I do this? May I accept this award because they're selling tickets, and I like awards. Appreciation's always appreciated. I like to be liked. Judges do like to be liked. They're just like everybody else. But there are, you can't have a situation that lends itself to people making big gifts to an event honoring a judge and hope of coloring that judge's opinion. But so you can ask the Code of Conduct Committee, you can put it out there, and they will give you an opinion. Now, the opinion is not law, but they'll give you an opinion as to what is ethical to do. And if the judge follows that opinion, the judge will not be liable under the Code of Conduct. So
And does that follow the same for disclosures as Professor was talking about? Some courts have different rules around
yeah,
disclosure.
the disclosures would work on everybody but the Supreme Court. And why they are not, I mean, these are not bomb throwers who are on the Code of Conduct Committee. They're appointed by the Chief Justice. So I think they should submit to the decisions of that body just like anybody else does.
It's a little tricky. That's
It
why.
is a little tricky.
So we are winding down to the end of our session. We again are so grateful to be part of this series. Oh, is that one more? I think the topic was the last question was asking, should this be this being, more education around judicial independence be part of civics training in the broader sense in regular education, early years of your.
Absolutely. And for example, I've sat on high school and junior and middle school competitions on the Constitution and also on moot courts. And that's a part of civics education that is so important.
Yes.
So
as we're coming to the end of our time, we are grateful at the University of Washington to be part of the AALS Teach-In webinar series. And we look forward to the audience joining the next session, which will be organized by Georgetown Law Center on Ethics and the Legal Profession, and in conjunction with Fordham University School of Law and their Stein Center for Law and Ethics on the professional independence and the Justice Department. So thank you again, and we are grateful for this teach-in and continued dialogue. Please join us at our symposium next week. We do have hybrid links for you to join.
thank you.
Judge. Thank you, Professor.
Thank you.